in the way, and so a few days later you have the code. So it's fantastic that all of you are here. I'm Michael Birnhack, and together with Tal Morse, we are the academic organizers of this conference. I will just say a few very short, brief words. First, especially for the guys online, we are recording the session. So if you do not wish your photos or other comments or whatever to be recorded, so please switch off your camera. And this is consent as of now on Israeli law based or GDPR or wherever you are.
That's the expert.
I acknowledge that people have the right.
It's regarding consent.
It's not. Here's the consent. Okay. So thank you all for joining us once again. This event is made possible with the collaboration of two research centers here at the faculty, the Edmond Safra Center for Ethics and the newly established, it has a very long name, the Chief Justice Meir Shamgar Center for Digital Law and Innovation, directed by our friend Niva Elke. We have 5 papers today. For each, we will have about 45 minutes in total for our discussion. So before I begin, just many thanks. The video died. Here we are again. Many thanks to Eilete Gozi-Christian for organizing everything, and Shelley Pasternak for being of tremendous help today. And I'm handing over to our Dean, Ishai Blank, who has the ceremonial role of greeting us. Please greet us.
So good morning, and thanks to Michael for inviting me to greet. It'll be very short. I just wanted to say how thrilled and excited I am about another activity that the newly established Meir Shamgar Center for Digital Law and Innovation is organizing, of course, with, well, not with assistance, but with motor engine capacities of Michael Birnhack and Tal Morse. The topic is extremely fascinating. I've known Michael and Tal work on it, but I didn't know that it spurred so much interest. And obviously, this is already a budding field of research and of great importance. I do want to say thank you again to the Edmond Safra Center for Ethics, the J. Edmond Safra Center for Ethics, and the Chief Center for Digital Law and Innovation. And I'm sure we're going to have a tremendously interesting day. Thank you so much.
Thank you. Should be glad. Just one more thing. I'm especially excited about this event because the initiative came from a former student of ours, Maurizio. Raise your hand. That's Maurizio. Maurizio studied here. His LLM a few years ago, and now he's pursuing a PhD under the supervision of Lillian Edwards, who's sitting next to him. And one day I received this email from Maurizio saying, we are all working on this topic. How about a workshop? And here we are. So thank you, Maurizio and Lillian, for backing up. And Edina Harbinia for joining this project. It's wonderful to have you here. Further ado, this panel will be chaired by my friend and colleague, Professor Niva Elke, the director of the Meir Shamgar Center for Digital Law and Innovation.
I'm not going to. Good morning, everyone. Those of us who are here and those of us who are on Zoom. I must say that I was less excited about the topic of today because it's a bit morbid. Let's face it. And there is some, but I guess the sun compensates for that to some extent. But I think. When I looked at the program, I think that there is a lot of ability of great intellectuals to go deep into the issue, and also to provide some insights on the way in which the past and the prospects of the future is actually affecting our well-being in the present, which is a topic that I guess is preoccupying many of us only in this particular focus on digital remains. So welcome to the first session that would be on conceptualizing digital remains. And we have 3 papers. It should have 25 minutes. We'll have 15 minutes for each presenter and about 5 to 10 minutes to each commentator. Please take a look every once in a while to see my notes, because I will actually take the time in order to allow for the audience to raise questions. Those of you on Zoom, please raise your hands. I'm going to see them, right? I'm going to see the. No. Not you, the commentators. I actually meant the participants who want to raise questions. We'll try to give an opportunity for those audiences to participate. Raise your hand in order to signal that you want to participate.
Yeah, I will do in a bit. I've just got to get this done.
We'll try
first.
to coordinate that. Our first paper, postmortem privacy and digital legacy, a qualitative empirical inquiry, will be presented by Lillian Edwards. Right? No. Okay, this is a co-authored paper by Professor Lillian Edwards from Newcastle University in the UK. Dr. Adina, where is she?
Here.
Dr. Adina Harbin.
Sharma, darling.
Boston University, and it is also co-authored with Dr. Marita from Morse.
Yes, darling.
Rights Commission.
Yeah.
So we'll hear you.
Yes, I will do. Yes. Okay, darling. Bye. Bye.
Zoom guys, can you please mute yourselves? Thank you.
Thank you. Thanks very much for your welcome and for the invitation. We're really excited to be here, actually in such a lovely warm weather. I know it's cold for you, but I'm just so excited. I went for a run this morning. It was amazing. So thanks, Michael and Tal, especially for helping with all the logistics and the idea and inspiration. And we, as Michael said, we work together in various projects and conferences, and we're colleagues and friends, and it's really, really exciting for me to be here. This is a morbid topic, yes. Thanks for noting that, but we are weirdly excited with these topics. And when you see me smiling, it's not because I'm obscene or weird, it's just that I enjoy this research, or it's interesting for me, and yeah, and I like to spread enthusiasm if I can, not with them, but the related research. So this paper is a part of our funded project by the Leverhulme Trust in the UK, where we, in the first phase of the project, conducted a qualitative empirical inquiry into postmortem privacy and digital legacy. And in the second phase of the project that started this year, we're going to do a quantitative survey with a large number of the UK users to find certain things that Michael and Tal have already found in their research with Israeli users, and hopefully compare those findings and build on some of their interesting work around postmortem privacy and continuity principle that we'll hear today and everything else. So it's really, really great, I think, to have these synergies between our research. So with this research, we tried to interview stakeholders in the area, so not the users. And the aim was to interview primarily legal professionals, a large number of them, but also regulators in the UK, tech companies, and the civil society. We were mostly successful. with the sample. So we were very successful with recruiting legal professionals. As you can see, those of you who have read the paper, we interviewed 13 lawyers, legal professionals, 10 of them from the UK, 2 from Canada, and 1 from the US. We recruited 3 members of the regulator, the Ofcom, which is now becoming this obscenely massive regulator of the online world in the UK with the online safety bill. They already regulate broadcasting and telecoms. So that was quite a success. We interviewed, so that's 16, and the 3 interviewees were coming from the sort of funeral business or the digital death profession very broadly, digital death management profession. We were not successful with interviewing the companies. And this is an interesting finding in itself. So comparing this to my PhD quite a number of years ago now, 5-6 years ago, when I interviewed Facebook and Google, this time I approached similar people, and in Google, the response was, so this is just for the for the workshop. I didn't write this in the paper, of course, but Google's response was they basically moved on, and they had nothing new to say, which is interesting. In Facebook, I had a contact who worked on developing legacy contact and memorialization policy. She was on maternity leave while we were interviewing, and she promised that she would engage with our research, but then she couldn't. And then when we finished data collection, she said she was into the interview, but we already finished. And they also, no one else was happy to talk about that, which again is quite interesting from the Apple side as well. So that's where one of the limitations of our study, but it also, I think, says a lot about the companies and what we knew before from our discussions with them, that this is a one-off project for a team within the companies, and then they just move on to another project, and they don't really stay or consider what could be changed further in this area, because of course this is a very small part of their business. And as we all know, and what practitioners here confirmed, death is not selling their product. It's not sexy, it's not, it is in a way, and the research finds that it does sell the product, and they do need deceased people's profiles and the data and everything that we know that they're doing with the data historically, especially for training the algorithms. But to advertise it and as a PR, that is not as we can assume, it's not very sexy. So in this research, I explained what our sample is. We interviewed these stakeholders to find out their perceptions of postmortem privacy, understood in a very broad sense that includes digital assets and digital legacy and digital remains. So not just privacy, but also monetary aspects of digital remains that Michael and Tal have also classified very helpfully in their work. And we conducted, actually, Marissa McVeigh, that was our postdoc and now is a lecturer at Queen's University Belfast. She conducted all the interviews during the pandemic. They were all online. The consent procedures had to be adapted, and she interviewed, and then we both of us did coding independently of all the interviews, and we approached it as a thematic analysis, and found five interesting themes that we thought arose from our research. So in terms of the anonymization, you will see that some of our respondents have been anonymized because they explicitly requested, which for me was a bit of a surprise because they are practitioners working in this area, and they were experts and they had a lot to say. They had vast experience and they worked in some of the professional associations, but they preferred to be anonymized. Fair enough. We anonymized their responses. Others were happy to be identified, and we confirmed with them that they were happy also to be quoted, and they checked their transcripts. So yeah, I think ethically we didn't do anything dodgy, and it wasn't a challenging project ethically because of the nature of our participants. That none of them was vulnerable participants, and there was no concerns around that. Okay, so our hypothesis that came out of our previous research and work in the doctrinal and theoretical shaping of the area of postmortem privacy and digital remains, digital assets, was that there is a lack of awareness and appropriate practice around postmortem privacy and digital remains amongst these key stakeholders. So that was the hypothesis that we, of course, expectedly confirmed. So Lillian and I had a discussion earlier, and we said, like, well, did we find anything really new in this survey that we didn't know or have a gut feeling about or had conversations with or just knew from our doctrinal and other work? We didn't. Maybe small bits and pieces that I will emphasize, but I think that the data confirming what we know is significant, and that we have something to back these assumptions with, even though it's limited, of course, in this case to the UK and branches out a little bit to the US and Canada in terms of the professionals that we interviewed. I think it's quite our findings could apply to a lot of other places in the world from, again, our research and comparative research and other people's research and our knowledge. So that was, I think, enough about methodology, and there's the methodology section, and I welcome comments and input, especially from social science colleagues who will be able to criticize our legal use of social science method that might not always be perfect or, you know, very well done. So moving on to the results, which is a section that was drafted in this paper, and unfortunately the discussion and conclusion, I only had time to just write bullet points, because I was working on 2-3 other papers, and one of them, again, with Lillian and Ghostbots, that will be coming out very soon in computer law and security review. So the results section is there. It will be tweaked, I'm sure, and we have already a conversation about it, and I look forward to the comments from the commentator and questions and the suggestions from everyone else here. But we grouped our results into 5 themes. The first one is awareness, the big one that came out from all the interviews, and that was our biggest assumption and what we would find. The second one was around taxonomies, the understanding of our stakeholders, what the key notions in the area are: postmortem privacy, digital legacy, digital assets, digital remains. Do they understand? Do practitioners, in particular, the lawyers that work in the area with the clients, do they understand what this is? And the findings are mixed, especially when it comes to postmortem privacy. There is quite a lack of understanding amongst the practitioners, which is no surprise, because the law does not regulate it, and thank you. And there's no accepted definition in any statute, case law, etc. So again, that's not a big surprise. The third theme is platforms and technology, something that a lot of us have discussed from various disciplinary angles. The problems with platforms that include access to these assets, their policies, terms of service, their goodwill in dealing with this area, etc., and all the obstacles that particular practitioners and their clients face when they try to access the assets of the deceased. The fourth theme was the limitations of current practice, what the limitations of practitioners face, not just in terms of technology, but in terms of the awareness of their clients, in terms of the law, in terms of the policies, in terms of practical limitations. And the fifth one was the change. And most of our stakeholders had quite interesting and clear ideas as to what could change to make their work and their lives more easy. And the biggest suggestion from all of them is, again, expected. We need the law reform. We need to change the succession law. We need to change the wills law. We don't have any ground in our work, so we are basically making things up as we go. They've developed some interesting examples of practice, like the checklists, like the prompts, the usual questions that they ask their clients, and the Society of Professionals working in the area of wills and probate at the global level, STEP, have their own guidance and checklists that some of the UK practitioners use. But again, this is imperfect as well, and practitioners have changed, have shared their issues. So I know I don't have much time left, but I think what I will emphasize is that in terms of the awareness, the biggest issues that prevented much a larger awareness in this area was the death taboo, in particular, the reluctance of people to contemplate their mortality. That's evidence in social science and humanities literature in this area. Generational divide, of course, younger people who have mostly don't really make wills or contact practitioners, but if they do, they would show much bigger understanding. But even then would emphasize crypto assets mostly, or the more monetary assets, and only would they think about communications and other remains if they're prompted by the professionals. And what some of them emphasized was also the benign neglect, that people generally don't make a long-term plans, especially in this probate and succession area, and that also applies to digital assets. And of course, media literacy, unclear laws. So that's in the areas of awareness. In taxonomies, I said a little bit already, and it's written in our draft that practitioners and regulators and morals don't really show a huge understanding of the notion of postmortem privacy, but they do show understanding of the digital assets as the concept a bit more clearly, because the concept has been there for longer. It's more digestible in terms of, practitioners like to think of property and contracts of the notions that they deal with on the daily basis. In terms of the platforms, the biggest problem, as we suspected, was finding and accessing accounts of the deceased, having a huge number of accounts that the inventory would not include, problems with identification, problems with the US companies asking for a court order that would not be a grant of probate, which is a court, as we discussed before, in the UK. That's which one. I forgot to mention in the awareness that one of the big things that came out was the impact of COVID-19 pandemic, which was a new finding for us. That post-COVID people were a bit more aware and were a bit more prompted to think about death and do something about their general wealth and assets, but also digital assets. So that did change and create an impetus, not just for people's awareness, but also for the digital death industry itself that developed and the different forms of wills, etc. Thank you. In terms of the limitation of current practice for the practitioners, the key issue that we found, I'll just mention briefly, is the lawful access to the accounts. That there were some comments around the Computer Misuse Act and unauthorized access to the accounts, the unclear legal status of digital assets. What are they? Property, copyright, data, contracts, the problems of privacy terminating on one's death, and the copyright stored on inaccessible accounts. And copyright is something that practitioners would find more easy to manage. So in terms of change, we grouped the change theme into the impetus for change and drivers for change and the actual suggestions for change. And there were some very interesting proposals for change, ranging from very practical law proposals, such as this is a very UK specific thing, the Norwich Pharmacal Order that's used for injunctions in the cases of privacy and information. And here they suggested that something similar could be used for digital assets and accessing those, to a more comprehensive law reform, the role of academia in helping raise awareness and to change, the role of the media, and in particular in the UK context, the role of a high profile big shot case, like we had cases in the privacy area, Max Mosley or Naomi Campbell, or the big cases. We didn't have those cases in this area. And a lot of the practitioners that just kept repeating, we need a big shot case, something that will open this up. So that was the themes, and I'll just wrap up now with our very brief conclusions. I mentioned the limitations of the study. The conclusions is that we did find some valuable data and some confirmations of our previous assumptions and theories. Important findings about the lack of clarity in the area, the need for change, the need for practical, legal, technological policy change, divergent practices within the legal profession in the UK itself, let alone somewhere else. Some excellent examples of good practice that practitioners came up with on their own, and the urgent need for law policy reform that could be helped and supported by the media, academics, civil society, and celebrities or public figures that would bring this into the court.
They have to die first.
Yeah, so they're kind of, you know, the case that involves a public figure, to be more precise. So that was it.
Thank you, Adina. I'd like to invite our commentator, Professor Shelley Levy from the College of Law and Business. I think that it would make sense if.
Is it here?
No, I will sit here. I will switch with you. I think that we need both of you for the Q&A.
Exactly, just move the mic.
Okay. Let me just say that I'm no stranger to morbid topics, as I've written quite a bit about succession law. So I want to thank the organizers, Michael and Tal, for inviting me to participate, and the authors for giving me the opportunity to engage with their work. And I'm excited to comment about this paper. I think it brings up a lot of interesting ideas and themes, and it offers a new perspective to the study of digital legacy. And also combined with the author's larger body of work presents an important contribution to the field, not only empirically, but also theoretically. And so in this short comment, I want to make 3 points. So I'm going to talk about the role of professionals. I'm going to talk about death and terror management theory, and I'm going to talk about overlapping the concepts of privacy and property in the literature of digital legacy. And so, to my first point, the project presents and discusses the perspective of professionals working in the field that the authors called postmortem privacy, and some people call digital legacy, and it can also be referred to as digital remains, as per the title of our workshop and Michael and Tal's work. And I will refer to all of these terms interchangeably. So forgive me for that. So professionals are understood as key stakeholders in the field that help us map the challenges of this emergent. And we can see that most of the respondents are legal professionals. And so I would like to ask, what can we learn from this particular perspective of legal professionals? And I think it adds something new, and that is the study of the sociology of the profession. And so I see 2 sort of layers of analysis here that comes up from the discussion in the paper. So the first level would be, in the absence of clear rules and regulation, professionals are claiming a new area of expertise, right? A professional field that requires specialized knowledge. And so even though some of the respondents are estate planning lawyers, they point to problems that are sort of outside the scope of traditional estate planning. And they also raise issues of awareness, which I found very interesting as part of claiming and, more importantly, defining the field, because awareness is only a problem if their expertise matters, right? And then the next level, after claiming expertise, we should ask how professionals conceptualize and understand their role in helping clients. And here again, in the absence of clear rules, we see that first they alert clients to the problem of postmortem access. And then we see that they help them navigate the procedures, right, for claiming postmortem access. But they can offer little knowledge of substantive law. And that actually falls in line with some sociological studies about the actual practical role of lawyers that has more to do with navigating procedures than actual sort of mediating substantive law. And so that was my first point. My second point, the authors mentioned terror management theory as a theoretical foundation for empirical research in the field. And I'd like to pick up on this proposal and think about potential contribution to this area of digital remains. So terror management theory is a social psychology theory, as the authors mentioned, that maintains that awareness to death creates a primal fear or terror that can then be alleviated by engaging with projects of meaning. So these could be cultural worldviews, these could be belongingness to groups like friends or families. These are key examples. And so the idea is that we have defense mechanisms that allow people to achieve symbolic immortality. And these are called anxiety buffers. Now, I've done some work on succession law, the institution of succession as an anxiety buffer, and I think that digital assets, or remains can also serve as a means of symbolic immortality. And but then we should have to, again, I want to ask, what can we learn from this? And I would like to suggest two possible research questions, further research in the area of terror management theory and digital remains. So the first would be, I find very interesting, do users who are aware of postmortem privacy issues perform differently online, right? So as we know, we see in the paper, a lot of users are not aware of the problem, and this is also backed by other research in the field. So does death awareness make users more mindful of their content creation, and perhaps, as some studies in terror management theory suggest, more conformist and express mainstream views? So there's a notion that the fear of death pushes people towards the mainstream. And it would be interesting to explore its applicability in online activity after being reminded of the problem of postmortem privacy that's sort of provoking or creating that awareness. So that would be one research question. Another research question would be, is the fear of death the reason for users perceive indifference or lack of awareness as to digital remains? So we see that in the paper, in the discussion, this is one of the explanations that come up, and we also heard it here in the presentation, but there's another explanation that also sort of comes up in the discussion, and that is that people lack technological proficiency and might not be as attentive to this issue as they are to other property issues. Okay, so that was my point about death and terror management. And to my final point, it concerns the overlap of privacy and property. Okay, so although some of the postmodern privacy issues concern property, a lot of them have to do with access to information, which is more of a privacy issue. And so these two concepts are frequently used together, both in the discussion, in respondents' interviews, and in the literature more generally. And well, I didn't expect that. So if the problem is mostly a problem of access, what explains this strong emphasis on property? And I think this is particularly interesting because we see that it's being characterized as part of trust in the state law and part of the trust of the estate planning process. What explains that? So I think there are two reasons, and then I'm going to explain why I think it's problematic. So I think there are two reasons. First, some of these remains do involve property or intellectual property or sort of assets that have economic value, and no wonder that cryptocurrency comes up a lot as something that clients care about. But another explanation is that property is sort of the main path of posthumous control in common law countries that don't have postmortem personality rights. And so thinking about digital remains as property works better under current law, but I would say that it creates an overemphasis on property that is problematic because it serves to conceal the involvement of the platform and corporate power generally in shaping activity, at least when we are talking about social media platforms. So Ronit and I have written, Ronit here and I have written about it. Activity on social media is manipulated. The platform encourages hyper engagement. There's hypersensitivity to feedback, and there's over-documentation of the self. So thinking about social media as property neutralizes platforms' involvement in the activity. And we suggested that instead of relying on property, we need to ask how the agency of the user can be protected in this balance of power. And so, at least when it comes to social media activity, I think that the property conceptualization is problematic. So, to sum up, right, these 3 points, the role of professionals, depth, and property conceptualizations, point to the richness, I think, of the insights drawn from interviews and the things presented in the paper. And I want to thank the authors again for their fascinating paper. I very much enjoyed thinking about it and engaging with it.
Terrific, thank you. We can stay here, and now it's time for questions. I open the floor here, and you see anyone over there, you know, we can, pick up the questions from Zoom.
This may
Introduce yourself.
my name is David Merchant. I'm a partner at Maytar, which is a big law firm in Israel, and I teach at in the law and technology program here at Tel Aviv University. So this may confirm exactly what both of you said, which is there's a lack of awareness and knowledge. So with that preface that maybe this question is really silly, which is on the privacy side, not on the property side. My question is, if I, as someone, just take, Facebook, if I was willing to post it in my life, why would I now have the privacy, expectation of privacy or concern about privacy in death? And is it because, maybe in life, I also closed my, the people who could see this. And if there's a legal regime that doesn't have post-mortem privacy, then maybe that gets open to the world. So anyway, that's my question on the privacy side. The crypto, I get it. The good thing is with crypto going down in value all the time, and property issues are looking less.
And you have to have the currency before you have.
Yeah, right.
Okay, sure.
Yeah, just briefly, I think it's a great question, and I think it's more for Michael and Tal's paper later, because it's about the users, and that's our second phase of the project about user perceptions, and it is about continuity principle that you talk about.
I can just add to that, because I think you are very much speaking to Michael and Tal's paper, but you make a kind of an assumption there that most things that are published are published openly on the internet, which is actually not true. I mean, if you think about emails, right? Emails are generally quintessentially private, unless they're going to some kind of office address, right? So the assumption that everyone puts everything out there and therefore they don't care what happens to it after their death is I think not actually axiomatically true.
And if I can just take the opportunity to thank the commentator, and I think you've improved our paper a lot. I was making notes, and you've drawn some of the things that I haven't made very explicit in the paper. So I really, really thank you for that. I think just my observation on your term management theory and questions about the users. Again, it does come out from the comments from the professionals. They talk about users and their experience, but we're also going to talk about with the users themselves and ask those important questions that you noted, and that's really, really helpful. Thank you.
Yes, please.
Hi, I introduce myself first. I'm also a partner at Maytar. I work with David Merchant on privacy matters. Ignacio, my name is Ignacio. Before I moved to Israel, I was involved in the right to be forgotten litigation in Spain. After the court of justice, ruled the Costeja case, and Spanish courts had to apply the case and decide in which case, the Google's legitimate interest would prevail over people's privacy rights. Just for background, my question is when conducting this study, particularly when interviewing people and the legal professionals, did you come across the actual policies that the technology platforms have to decide when to delete accounts or when to delete information? Are those policies public? Are they not public? Do they decide these things on a case-by-case basis in light of the particular, context or facts? Like, what can you tell us about policies? And by the way, sometimes we think about Google, Facebook, and the big social media platforms. The truth is, like, people sign up and create accounts in all kinds of services, and presumably all platforms should have some kind of policy to do with these things.
Yes, so the practitioners, that's one of our things, the platforms and the tech in the paper. We know colleagues who work in the area that Some companies have policies that have been developed over the years, including Facebook and Google and later Apple. But majority of other smaller companies and companies that our respondents were dealing with either didn't have any policies or were really vague about this area. And even the big ones that were of most interest to most of the clients and our professionals that we interviewed, such as Google, Facebook, and Apple, they have certain policies of legacy contact, memorialization, deactivation and deletion. And whereas legacy contact perhaps and memorializations are clearer, not many users are using them. And anecdotally, and I cannot sadly quote them on that, about 1 to 3% of users have used those tools. And when they haven't used them, that's where the problem comes for the legal professionals, because the policies are not clear on when they disclose and to whom, in what time period, how swiftly. And they often, the professionals said that talking to Apple, Google, and Facebook, they require court order and they don't recognize the grant of probate. They just want the proper court order in cases as they see it from the American law perspective. And there was one case involving Apple, the Thompson case in London, where the judge ordered access to the iCloud, and the judge himself said we need the law reform in this area. So yeah, the answer to you is that the existing policies haven't been used much. The existing tools in the service haven't been used much by the clients, and we know that for discussions as well. But where the other policies exist around access and deletions, they are not transparent, they're not detailed enough, and the professionals struggle to navigate them and struggle to communicate. So they cited the lack of goodwill, the lack of just openness from the platforms and companies.
Thank you very much.
Hi, Sarah. Could you just stand up? Hi, I'm Sarah Clayton. I'm a law student at the College of Law and Business, coming from the high-tech world and data specifically. I'm curious if the next question from both of your presentations is what are the next steps in terms of this field? It's a niche within a niche, and I feel like people can't even agree on there's so much controversy about privacy while people are living. All the more so once they're dead. So I'm curious, like, what the next step for this whole research thing is.
Yeah, there are quite a few next steps, I think, depending from the angle you're coming from, and all of us are coming from similar but also slightly different angles, and in terms of the law and social science and humanities. For my research personally, the next steps would be the law reform in the EU, hopefully, ideally, and the UK, but also policy changes and somehow convincing tech companies to do more, to provide more transparency, to provide more granular solutions that people have suggested. And just working more on from the academic point of view and the academic perspective on conceptualizing this area, evidencing the importance of the area and the growing importance as more and more people die.
I mean, Izina, is it not worth mentioning the work you've done about the uniform model restatement in the US, given that most of these tech companies are in the US? I think that's the most significant next step that's happened or is happening.
Yeah, it happened in the US. We have they have the RUFADA, the Revised Uniform Fiduciary Access to Digital Assets Act, that has been adopted by the majority of the states. But as far as I know, again, I haven't done empirical research, but talking to my contacts and lawyers there are problems with the actual enforcement and application of those model laws and the laws in the states. There is some movement at the European Union level that I'm also involved in, and just started to co-lead a project with the European Law Institute to develop either a directive proposal or a set of mandatory rules for the EU, which will be very challenging because succession and property are not the competency of the EU, but of the member states. So we'll see how we navigate through that. And the UK is very much behind with.
But I think that is a giant step forward, what's going on in the US, because, it's buried in the detail. that's really a statement in most states that at least in principle, the administrator of the estate should be able to get access as they would to normal assets in a bank to the assets on the digital platform on Facebooks and Googles. And that's a huge step forward that's happened at the time we've been researching this.
Unless the user have made use of the in-service solutions, which take priority even over wills.
But as we've said, very few people are
Yes.
using those sets.
In
Almost,
practice,
almost completely irrelevant. In practice.
Exactly, yeah.
That's true.
Hi.
My name is Morse. I work with Michael on what digital remains. I hope this does not come as a provocation in this room or in this faculty, but why should it be lawyers who will accompany this process?
Go out.
What if there is a huge amount of aspects or many aspects that are involved in psychological processes and other social and cultural aspects, what makes lawyers the best choice to be the profession that will take charge on this process?
I think that's an excellent question, and I think that's where Lillian and I would probably disagree, and I would more agree with you. I see where the lawyers would struggle to understand and capture this area properly. I think for our research, because it was empirical research and by now what's there, they were all we had. And they were like the first obvious point of contact when the clients come and talk about their assets and their digital assets, their digital remains, they would speak to their lawyers. But I do think that the solutions in the future and going forward would be some form of a mediated disposition of those assets, either to technology or technology plus some form of digital executors or other forms of trustees, not necessarily legal profession, because there are obvious obstacles and problems with that. Not just legal, but also potentially normative and theoretical and other reasons that we discuss and others discuss. But Lillian probably disagrees.
Well, I would just say straightforwardly, you know, if there is any estate where anyone has to take any actions, as opposed to the vast majority of states, as I understand it, when I used to teach succession law, that are either intestate and no one does anything much about it, or there's a house and it kind of automatically transfers to the surviving spouse or children quite a lot of the time. If there is a will or if there is any significant assets to be dealt with, then you need a lawyer. You need a lawyer. You need someone who's going to go and get your, whatever you call it in your system, you know, an order for probate, an order for confirmation in Scotland where I learned this stuff. So you've got to talk to your lawyer, right? No one else is probably going to care except for maybe your grief counselor. Right. So that's the other obvious. Yeah, I think it isn't actually funny. I mean, I think one of the people that we both know who's worked in this area is a grief counselor and watches the grief psychologist. But the lawyers are the absolutely obvious people to talk to. And I must admit, I wish I'd thought of this months ago. It occurred to me talking to Edina this morning that what we should do is an empirical study of what goes into the inventories for probate, right? I mean, I studied this in Scotland, so I'm not sure if it's exactly the same in England or in other common law jurisdictions, but in Scotland, you have to write down all the assets, right? And put them in this form into the court to get your order for probate to ingather the assets, right? And I assume most systems do it similarly. So you could actually do a completely objective, empirical, quantitative study of simply what's in those inventories. And I think that's kind of what I'd like to do next, actually. Because I'm practical, I'm not theoretical.
So continuing on this point, I would like to offer a comparative element. A colleague of ours, Daphne Hacker, was actually visiting at King's College right now, and Dan is the dean of King's College.
Yeah.
So we have an exchange apparently. Daphne has studied Israeli wills. She has read hundreds of wills, and what she came up with was that they tend to be extremely technical, legal, very short, dealing only with property. And we have, Tal and I have considered doing a similar empirical research with Israeli lawyers and professionals, etc. We called a few friends informally, and they said, no, we don't deal with that. And nobody does. And these are very prominent family lawyers, as we would call them over here. They don't deal with that. They don't want to deal with it because they are, it's overwhelming for them. It's too fuzzy. They know how to deal with property, with an apartment, with bank accounts, pensions, things like a car, art, jewelry, whatever, and that's it. And this is too new for them in this regard.
Can I just add something I missed and we discussed this morning as well as important and going back to your comment about lawyers helping navigate the unclear area of law. There is also this question of risk and liability for the lawyers if they provide wrong advice and if they mislead their clients. So that's why that was one of the reasons that quite a few our respondents cited as the problem.
I
So
think,
they
I
were
think
like,
for me, that's the most interesting thing we found actually, is because I would never have thought of that because we think of lawyers as enabling. Or maybe that's a controversial statement. I mean, like my brother's a lawyer, I know a lot of lawyers, I think they think of themselves generally as enabling rather than disputational, maybe it's different in the US. But the finding that people would steer away from advising their clients on this or advising their clients to think about this because they would worry that that might get them into deep waters of possible malpractice. I think it's really, really interesting. And actually, I'm now sad in a way because I wasn't involved in the interviews. I would have gone back and pressed on that one, I think. And I wonder if we can do maybe some follow-up interviews on that in the next stage. So that's interesting that there's a disincentive in that.
I guess we'll have to stop the conversation here, even though I think that this is a really interesting point where that also linked to the point of Shelley about the role of platforms. The question is, this is something at the intersection of privacy law and property law, and the question is whether this only creates a cost for platforms or whether that is also creating a business opportunity, because then you would expect that they would not worry about liability issues, right? And they would want to promote this as a business, offer that as another type of tool that people can use. And I think that one of the interesting questions in your data is to look up, whether this is a cost-provoking thing for businesses or whether this is something that can create a value, and therefore it's interesting to ask why market did not provide for it.
Not wanting to take up more time, but I think what's happening right now, and some of this is in Mauricio's paper and the work we're doing for his PhD, is that opportunity of building a digital assets industry, as it were, an after-death industry, seems to be being picked up by individual entrepreneurs who are in some way personally incentivized, often by someone they know having died or whatever. It's rather strange and niche in sort of the same way as lots of other things are, like infomediaries and, and the lawyers themselves, I think, don't see it as a seller for exactly the reason that Edina has said, which is that people don't like talking about their death. So you're on safer grounds with very familiar stuff like you must make sure that your partner gets the house. You must make sure that your children don't squabble over the bank account or the car or whatever, right? These are very familiar litanies, as opposed to raising unfamiliar, unsettling issues. That's my guess.
Thank you. Thank you. I'd like to now invite Michael and Kyle, Professor Michael Birnhack here from Tel Aviv University Faculty of Law, and Dr. Tal Morse from the Department of Photographic Communication at Hadassah Academic College in Jerusalem, and they will present the paper, The Continuity Principle of Digital Remains.
I will be presenting.
Make your will.
Sure.
Okay, so good morning or good afternoon, wherever you are. I'm happy to share with you my and my article titled "The Continuing Principle of Digital Remains." This article is part of a larger project that we started in 2017 on the norms and regulations of access to digital remains. The project has yielded several publications, and the one I'll present today was recently accepted for publication by New Media Society. In this study, we conducted 8 focus groups in which we probed into how people understand the idea of digital remains and related aspects of accessing personal online accounts posthumously. The discussions in the groups revolved around issues of impression management and privacy in life and after death. In the article, we proposed the continuity principle of digital remains to capture the pervasive normative stance that advocates for the continuation of privacy management from life to after death. Generally speaking, there are 4 possible scenarios in this area. To illustrate them, we will introduce 4 fictional characters. Alice, a savvy Twitter user with thousands of followers, that once she dies, the platform deletes her accounts and content that she posted online is inaccessible anymore. Bob, who shares content via locked accounts, but once he dies, the platform remove the locks and make his hidden content accessible to everybody. Charlie, a student that was killed in an accident, and his parents request access to all his accounts, including dating applications. And lastly, Diana, whose accounts settings remain untouched, so the data that she shared remains accessible or inaccessible according to her ante-mortem preference. These are 4 scenarios that are possible, basically. Theoretically, we apply the framework of impression management to the posthumous condition. In life, people manage their impression and exercise control according to the context, online and offline. However, once people die, they still leave behind their digital remains, which reflect the personality they crafted. But once they die, they can no longer respond and can no longer control the ways in which their persona is presented in various contexts. So what did we find? We are unable to present all the findings, so we'll focus on the main themes. Some participants said that this is too daunting to consider their posthumous impression, that life is about here and now, and this is something that also the networks encourage us to think and act accordingly. So Sharon told us that when you write a post, when you post it, you don't think about what you'll leave behind. This corresponds with findings from our previous research, which suggest that people avoid dealing with their departure, and only few have done something to manage the access to their digital remains. However, we can see that people have conflicting approaches here, and while some people suppress death-related issues, others do plan for the day after, and some participants said that what they leave behind indeed crosses their mind, and that they deliberately generate content that will facilitate their commemoration. So Becky told us that there are things about myself that I want my daughters to find out after I die. And Tanya said that when I travel, it is important for me to take pictures for 2 reasons. So I can remember these places, but also to leave something for others to remember me. And this is based on her previous experience with the loss of her brother. Some participants pointed to the possibilities to manage the ways they present themselves in life, online and offline, and the lack of possibility to control the impression management posthumously. Karen told us that many people hide in the digital realm and present something that is not them. And it is not something that I want people to find out after I pass away. When it comes to information about others, we see that sometimes people want to protect themselves from what they perceive as harmful information, or that they have, or to have better control about their own reputation, as they fear that something about their loved ones will shed bad light on about them. So David told us, I wouldn't like to learn new information about my father that I don't really know, that I don't already know. And Adam said that, gave an example of parents of ultra-Orthodox family, in an ultra-Orthodox family, that if something will be revealed about their son after he dies, and which is not in line with their tradition of living, it will shed bad light on the parents. And some participants were fierce advocates of posthumous privacy. Karen said, today, most of our memories, like most of our personal stuff, are stored in the mobile device. This personal information is mine, and I don't want others to read it. And Chris said, this is my privacy. It doesn't matter if I left a will or not. If I did not make some information public in the first place, don't touch it. We found that respondents associate posthumous privacy with respect towards the dead, and accordingly, they believe that we as society should respect ante-mortem choices. Jane said, I wish I could consume all the information about a friend who died, yet at the same time, I want to respect the dead. So how can we tell if online content should be accessible or not? The participants suggested that the platform on which the data was originally circulated and stored indicate the status of the data. The type of platform tells us whether the data should be accessible or inaccessible. If something was posted on a public platform, it should remain public. But if it was originally intended for a closed circle, it shouldn't become public posthumously. Adam said, gave the example of WhatsApp application. One-on-one WhatsApp messaging is out of the question. If I corresponded with someone on WhatsApp, I never intended it to go public. It needs to remain private. And Joel said that if gave the analogy to a drawer, if you lock stuff in a drawer, you do it for a reason. I wouldn't want anybody to unlock it. Our analysis of the focus group resulted in identifying the continuity principle in digital remains, which means that users have expectations for posthumous privacy, and they think that society should respect these expectations. They believe that technology should meet these expectations and signal whether the content should be accessible or inaccessible, and that the boundaries of access to personal data that were established in life should persist posthumously. This corresponds with Diana's scenarios that we presented at the beginning of the presentation. Participants in the focus groups believe that a person's decisions concerning sharing information must be respected after death, even though the data subject can no longer control their personal data. These perceptions align with Birnhack's circles of privacy and also with vision-bound contextual integrity, which most participants believed should linger after death. And this also resonates with Adina's work on posthumous privacy. Most participants distinguished between how users manage their personal information in public versus private spheres, and favored extending these distinctions positively. However, we should remember that people hold diverse views with regards to granting access to their digital remains. Based on our previous study, we can see that people think that the content and the platform on which they posted something, they have different views about whether they want to share this information or not. And we also found in another study that there is a lack of consistency between the views people express with regards to granting access to their digital remains and how they behave on that matter. So to conclude today, many social interactions are online interactions that leave digital footprints. Once people die, this content turns into digital remains that reflect the impression people manage online in their life. Upon death, these accounts are left orphaned. However, there are still various stakeholders who are interested in accessing these accounts. Yet users applying that in-life norms and choices should persist and survive there. All this should give us food for thought on how, if at all, to regulate access to digital events.
Thank you. Now we have to go out of the presentation because our commentator, Dr. Donit Kedar from the College of Law and Business will be commenting from Zoom. So I think we need to go out of the presentation so we could see her.
Yeah, can you see the presentation? Was I successful in sharing the screen? I can't hear you. Can you see my my presentation on the screen?
Users to leave us the system.
Yeah.
Are we still on Zoom?
Yeah.
Only.
There it is. So can you also hear me or just
not as well as we would like.
hopefully what happened to the okay.
Now we cannot hear at all.
Yeah, I'm here.
Can you please speak louder and we will.
I'll do my best. Is that better?
Yeah.
Okay, so thank you very much for inviting me to join and speak in this workshop and talk about the paper by Michael and Tal, which I really enjoyed reading. Also following their larger project on digital remains more generally. And I think both the paper and the general project are extremely interesting. They raise a lot of really important questions, new questions to be dealt with, both philosophical and practical. So it's a real pleasure to think about these things. I apologize for doing this on Zoom. I have to be present for my daughter's really important event. So I couldn't do both. So I'm sorry about that. I apologize. It was pushed back and everything. What I will do today is first I want to talk a little bit about the paper itself, because I want to show some points that Tal didn't mention in his presentation of the paper, and I will need them later for my comment, and then move on to commenting on a few thoughts that I had. So the main arguments of the paper are that the digital era calls for a new paradigm to deal with digital remains. The central question is what to do with posthumous privacy and impression management, especially since digital remains now are stored or activated by third parties, which are the platforms. And so new questions of access become more relevant than before. Before we could just enter the room of the deceased and just, you know, take whatever was there. Now we need the permission and the cooperation of a third party, the platforms. Tal talked about the 8 focus groups, so I'm not gonna linger on that. And the conclusion is that there is a pervasive normative stance that advocates for the continuation of privacy management from life to after death. Importantly, the theoretical framework of the paper is Goffman's impression management theory. And that is a kind of theatrical metaphor that Goffman uses for how people manage their social persona, putting on a show for different audiences, and depending on the crowd and the audience that they want to put the show on for. So as I am now speaking like an academic, and I have this presentation ready, and I'm dressed hopefully appropriately, this is one aspect of who I am. On Sunday, when I watch football with my friends, I am they see a completely different part of me. And that is the idea that people have some sort of control or choice about how they present themselves to the world. So Goffman talks about how before the internet age, he wrote this before the internet age, the interaction was face-to-face mainly. And today, in the post-digital age, our digital presence becomes front stage. So whatever that we put on the digital arena is who we are. In this sense, it becomes the face that we show, the show that we put on to the world. And after death, these digital footprint becomes our digital remains. And the paper tracks this offline to online shift, which I will later say a few words about. And it stresses the fact that online there's a context collapse, while face-to-face we can be whoever we want to be in terms of different audiences. When we are online, the audience is mixed. Okay, so it's not the same thing when I post a tweet on Twitter, then my colleagues from the academia see it, and my friends and people I don't know. So there's a type of context collapse. And also it is mediated by the platform. So to access digital remains, we need platform cooperation. And the main question now becomes a question of access and a question of privacy. Does privacy carry over from life to after death? And like Tal said a minute ago, the findings were what the authors call the privacy continuity principle, which basically means private data should remain after death for all kinds of reasons that they stress. So this part was the main points I thought were especially interesting in the paper itself. And now moving on to my thoughts and comments. So I'll first say something about the depiction of this online to offline to online shift, asking whether it's accurate, and does the Goffman metaphor apply here, and is it a proper metaphor? I want to say something about platform power, then say a word about privacy, and then a really short remark on digital remains. So in terms of, is the depiction of the offline to online shift accurate? And it's important because it has a bearing on the use that the authors do of Goffman's metaphor of the online presence. And I think that while Goffman talks a lot about the control that people have when they put on a show, I am not so sure that this it works in the same manner when we talk about the web, online presence. When we talk about our online presence, we need to remember that the web documents everything that we do, likes, shares, all of our searches, all of our Waze routes that we traveled, the length of time that our mouse hovers over a photo or a tweet or whatever. So all of the stuff that would usually just evaporate or would, be forgotten in a second, the ephemeral, the trivial, the unnoticed, all becomes recorded and lumped into this huge mountain of data. And this is the point that Shelley and I, Professor Shelley Kaiser-Levy and I, wrote a paper about called Better Left Forgotten, really asking the question of how much of this massive digital data, which is personal on one hand, but it's so huge, how much can we really talk about a coherent online persona? So the claim I'm trying to make, the argument here, is that our online personal data is not who we are necessarily, or is sometimes who we are, but fractionally. And so when we try to talk about impression management, the web, or our personal presence on the web, is clutter rather than our impression. And we have much less choice of presenting ourselves or putting on a show than we would like to think. So Goffman's identity management theory, I don't think it always fits to our impression online, to the impression that we leave online. So I think we're dealing with two different questions here. The first one, which the article tackles, is should privacy settings continue after death? And even if the answer is yes, this question is very different from the question of, can we think of our digital footprint as digital remains and think of access to it as access to our impression, to our identity? And can we even think about our digital remains as impression management? And I think it's a more complicated question than we would like to think. The second point, which relates to the first one, and Shelley and I wrote on that as well in the same paper, is the platform power. So the study does discuss platform power, but I think in a very narrow kind of way. So the study discusses online commercial interests of digital platforms, saying that they need the desist data to train their algorithms, that they want to create a friendly space for users, and sometimes they even have contractual commitments to the users. But the question is this a sufficient depiction of the role that platforms play in this creation of our online personas? And I'm not sure that it is, because platforms have their business interests. They want us to, they encourage engagement, they need traffic. There are all these researches about the casino metaphor of when we don't know what time of day it is when we engage in the platform. We scroll endlessly, and it's all meant to keep us online, keep us engaged. And so it creates this accumulation of activity that we were streamlined into making. And then, is that who we really are? Is that my identity? I remember once that if I'm sure people on Facebook know how Facebook encourages us to congratulate our friends when they have birthdays, and then it becomes this competition of who got the most compliments and good wishes and everything. And my daughter once, when she was 14, woke up and saw this bunch of congratulations on your birthday and said, look, Mom, I'm so popular. I think I'm going to put it into my CV. So is it really who she is? Is it really who we are? What Facebook drives us to do now becomes this reflection. I'm not sure how accurate of a reflection it is for who we are. So this is another.
I'm stopping you. We are way beyond our time. So if you can
Yeah.
just try.
Yeah, so just one last issue, and it's going to be short. Is it privacy at work or is it something else? So the study finds that people are concerned with posthumous privacy. They say that they want to respect the dead, they want to respect their pre-mortem choices, and they don't want to know stuff, right? If the deceased has skeletons in the closet, they don't want to know about it. They're fine with the memory of the deceased as it is. But the question I want to raise is it really a concern for privacy, or is it a concern for the good name of the deceased? For instance, what would happen if the digital remains indicate that the deceased was this saint of a person, a do-gooder, contributed to society in many, many ways, no one knows about it, he kept it private? Would we then be interested in respecting their privacy in the same way? So I'm not that sure. I think that privacy here may be a wrong proxy for the good name of the deceased. I have one more issue, but I'll skip it. Leave it for next time.
Okay, great, thank you. Reacting to the comments.
So thanks so much, Ronit, for joining us and for these thoughtful comments. On the second point, on the role of the platform and how it changes our lives and identities, I think we fully agree about that. So I would just like to tie the first and third comments that you have made. Goffman's impression management, to begin with, is about impression, not about our identity. So the confusion about identity and privacy and all that begins there. So it's not a confusion, but he spoke about the way we wish others to think about ourselves. Now, a second related point is that it's only a power. It's not necessarily that we succeed. I would love everybody to think that I'm young and masculine and smart and whatever, but I'm trying to manage the impression that I give or give off, but I do not always succeed in doing so. So indeed, there's a context collapse in life and in life as well, not only online, offline and online. When death enters the picture, as one of our colleagues in one of the Zoom conferences online, I don't remember who, called it, it's a radical context collapse because we cannot respond. Okay, our identity once we die is sort of fixed. People can interpret what we have done or whatever differently, but it is we can no longer respond. And indeed, privacy it's not only about privacy. There are many things at play, but I do think that privacy is a proxy for impression management and for the goodwill, reputation, and those things. If I control my data in life and I wish it to continue posthumously, then I can at least try, without any guarantee that I will succeed, I can at least try to manage the impression others have about me before I died or after I died, etc. So privacy is instrumental in trying to achieve impression management or execute impression management.
Thank you.
Yes, thank you. It's
Let's introduce yourself.
Oh yeah, sorry. I'm an SAP PhD candidate here at the economic department in Harvard Law School. So it's really fascinating. I think I agree with your normative point, and I think whether you and also the empirical part is very well motivated because whether you care
the dignity of the dead or the autonomy of the living, or maybe also it was raised before, kind of how, it could distort behavior of the living if the law didn't protect well enough their interests posthumously. So I think it's all, and whatever your normative stance is, I think it's well, justified to have like an empirical kind of study that tries to understand what's the strength of the preferences of people, basically about those stuff. So I agree with the normative point. I think kind of on the empirical side, I would be very curious to kind of see maybe another dimension added that I'm guessing that you have, because it's kind of basic, about age, because I think there are like two things at play when we think about those stuff. There is kind of that what's your digital kind of presence, how large it is. I guess the larger it is, maybe the more you care about what happens with it, and this is very strongly correlated with younger age. But then again, like thinking about being aware of it and thinking about your remains is maybe something that happens, more as we age. So I mean, so one thing that would be interesting maybe to see the exact kind of drafts that you showed just for different age groups. But even then, I wouldn't know what to expect, because maybe the younger are less concerned of death but have higher digital presence, and then the older are maybe more concerned of death but have a lower. So maybe the next point is to kind of divide it yet another on another dimension to kind of show maybe if you have I know maybe how many platforms they're active on or something like that. That could kind of split the two dimensions. And kind of a very small last point. It's kind of for a different project. It would be interesting, like in 10 or 20 years, to run the same study, because it's also like a longitudinal. No, you're young in there. Yeah, that's good. Like in 20 years to see whether this all shifts.
Yeah. Thank you, Hagai. So this is a part of a larger project that we've been doing for several years. In one of our first studies, we had a quantitative survey, a quantitative study, and there we asked, what do people want? And the answer was one of the last slides, diverse. Different people want different things. In a second study, we asked what happens in practice, and we realized that in many cases, people's wishes, either for the content to be open or closed, do not materialize. It's often the opposite, which this is a paper on the paradox, posthumous privacy paradox. This paper was a qualitative, not a quantitative one. We asked people basically what do they think should be the rule, without them being, none were lawyers, I think, right? Maybe one was a lawyer. Yeah, but they were not lawyers. We asked them a normative question, and about age.
So the quantitative studies that we have done didn't show significantly significant differences between age, despite the assumptions we also had about it. And also in the focus groups, we had two groups of senior citizens, and they were very different groups. One was of very savvy users that are fully minded about the day of departure and planning ahead, and also knowing their way online. And another group of same age group, but in a different mindset. They were less active online, and they were concerned in the same way about the day of departure, but they were much less active online, and therefore they didn't plan and didn't do any other arrangements to address these issues. In another study that I've recently done, I did see something about kind of the level of engagement of people online as an indication of how much they are willing to consider digital afterlife, generally speaking. And one of the indications was that the more you are active online, the more likely you are to endorse digital technologies for managing your afterlife. The ghost box.
Thank you.
Abigail from the faculty. So I have a question that is both empirical and non, which is another kind of way to kind of classify the people along the line. But the guy's question is, would you consider a difference in terms of expectation of privacy between public figures and non-public figures? And you know, there's a kind of gray area in between. But I would assume my hypothesis would be that public figures would want to hold on to their privacy because they want to kind of separate a public figure or public impression and that kind of more personal one. However, from a minority point of view, I think those are the people who we want to kind of, in a way, intervene or intrude on their privacy for research questions, but also for, you know, freedom of speech, broadly speaking. We want to know who the person was exactly and not just what that person said. And of course, there are some kind of ex-ante implication for that, how those public figures would manage their information in real time, you know, anticipating the and so would you have something to say about those kind of things there? And that kind of other aspect, other side of this hypothesis would be that non-public figures, you know, that kind of lay persons who may be savvy, but they're not public figures, would perhaps have different kind of expectation about privacy. Perhaps they would not care about that. But from a minority point of view, I think we can imagine the kind of reverse principles, right?
So
That's really short because they have 3 more questions, maybe 4 and 5 minutes.
So shortly, the short answer is we didn't interview any public figure, or at least not anyone that we know of in the focus groups that we know that he or she were celebrities or anything like that. So we did not, you know, so that's a great follow-up study. I would imagine that public figures are pretty much aware of impression management in life and in death, you know, especially politicians, you know, etc. That's why they write books, biographies, autobiographies, etc. So it's a great point to look into empirically. We have not done that, but maybe others will. Thank you.
But I think that the whole concept of public figure is changing because now you have TikTok influencers with thousands of followers. Are they public figures or not?
Yeah, we want to forget that.
So thank you. That's really interesting. I have 2 thoughts. So one of them is within your data, I think that another interesting thing comes up, and that is sort of the interests of the deceased are intertwined with the interests of family members. And I find this really interesting. You see it both when people are interested in the family name and also the younger respondents that talked about how they would like their parents to have access because they see themselves as still part of this dyadic relationship with the parents. And I think it falls in line very nicely with other questions that involve death, like organ donation and succession law, where we talk about the wishes of the deceased, but actually, in fact, both in social perceptions and in the law, we see these interests intertwined. So it also comes up in the paper, and I thought that was really interesting. And my second thought was, I was thinking about a comparison. So I was looking into my own intuitions about a comparison to the offline world. And we can say, well, it's like letters or a diary. And I thought if somebody's mother had passed away, they would, when you find the letter, they would probably look at it, I would assume. But then I thought what's interesting is that some of the digital remains are more like conversations rather than letters. And so this is also something that you can sort of divide. Emails are more like letters, but perhaps, you know, my messenger conversations are more like conversations.
Hi, I'm Yasmin. I'm a PhD student at the faculty in Fellow at the Shamgar Center. Thank you so much. This interest is super fascinating, interesting. I want to keep my comment really short. I was just thinking when we're all talking about offline, online, and during life, person, a more private person. I just had a thought that once we die, I mean, it's not necessarily that whatever we agreed upon during our lifetimes that we would have this information to be to stay online. Even if we're the most or the least private person during our lifetimes, it's not necessarily what we want to be remembered afterwards. Because also, I think as time passes after death, I think at some point the only information that remains available is actually that was online, and whatever was probably offline people's minds that does not exist anymore. So the picture And I think many of our online interactions are basically do that even without thinking. We put a like here, a comment there. And I think if we were asked, or if somebody would tell us we would die tomorrow, if we want to go over our whatever we published, I think most of us would
We will do other
probably.
things.
Yeah, and I think it's quite. And I think it's in a way similar to succession. When people die, but they do not provide for a will. I think there are many people, they do have the intention to review their information. If they don't do it, so there might be, this might be also, I don't know, it's difficult like a legal regime.
Right, so very briefly to both kind of questions together, I will intertwine. I will join them. Offline, we have pretty fixed social norms about access to someone's drawer, etc., and what we want to remain after us or not. Online, it's still in the making. Can I access my beloved one's Facebook account, email account? It's unclear. And it came up in previous studies, the empirical ones, and in this one as well. And different people have different wishes about open in life, closed after death, or vice versa, and it doesn't always happen in practice.
Yeah, I don't know if I'm gonna make any sense, but because this topic is really complex, but I wanted to ask if you have considered looking at the concept of posthumous privacy also from the perspective of certain GDPR principles, like for example, storage limitation, data minimization, and the accountability, because it seems to me that at some point, it wouldn't be unreasonable for European courts to say that once a platform becomes aware of the fact that someone has died, and by the way, they could become aware of that maybe by, stopping, the user stops publishing, or the age that they have purely indicates that that person can no longer live, 200 years or etc., etc. At that point, they should be the one proactively deleting or reacting to the content. And as I was hearing very quickly, the different use cases that you explained, the concept that came to my head is like the concept of balancing test. At some point, the interest of other people may also need to be taken into consideration. So what is the right process of time to?
Very briefly, the GDPR does not apply here in Israel.
Yeah, I know.
That's one. We are supposedly adequate, but we are not really adequate. Secondly, in the EU, the GDPR under recital 27 allows member states to do whatever they want in extending some rights posthumously. Denmark, I think, has done it 10 years. Ireland, nothing, etc. So it varies within the EU, which means that whatever platform it is, will really have to choose the highest level or start differentiating different countries, etc.
Thank you. Lumi, the 30 seconds for this final thought.
Yeah, I just wanted to touch on what Shelly said about how offline some of our communications with others would be in terms of conversations, and when they are online, they become recorded forever. And I think this is a good example of what I was trying to say about how when we offline, we have much more control over our impression management, in the sense that when we talk to someone, we talk to a person and we know what we said. And even if we don't like it, it's gone by the time that we've finished talking, right? It's not there anymore. Whereas online, everything that we've ever said or written or commented on is there forever. And that is way wider or broader than our identity or the impression that we want to make. So that kind of links to the point I was trying to make with a better example than mine.
So I think that as we move from privacy to impression management, I'm now convinced by Tal's question, why should lawyers take care of that?
Get out.
Yes. Okay, thank you very much for a fascinating presentation. And last but not least, is a paper by Dr. Mustafa Chanel here from Tel Aviv University. It's congratulations. Just received your doctorate, what is it, a week ago, 2 weeks ago?
Yeah, approximately.
Okay. Terrific. And you will talk to us about meaning is used, functional analysis, and the emerging category of quasi-property.
Hello, everyone. It's a great joy and honor to be here in front of people I frequently cite in my own work. What I'll talk about is actually, I will try to incorporate the previous questions. I had a certain structure in mind, but I would also like to incorporate questions because they're actually relevant, because my structure was based on certain assumptions that seems not that much shared among all of us. So, starting from the last question, balancing interests. Exactly, like there are many stakeholders in digital domains, and their certain interests might be in alignment, but most of them are in conflict. So, assuming that there is a personal interest of a person, that was the first question, if I don't misremember. So why, like, maybe start from there, like, why should we care, like, about like postmortem privacy? So there are two spectrum, let's say. I think Prof. Levy and Dennis Kader's article, Better Left Forgotten, you were adopting, like, you were presenting and adopting being less vulnerable. So that a subject might be exposed to certain through violation of privacy, certain impairment, which may actually hamper her self-determination, information self-determination. Like we have studies like actually like showing that once you're aware that, or once there is a high percentage that your privacy is violated, your actions are actually not as they were supposed to be, like in a free. So like information self-determination plays along here. But this was a personal aspect, and there is also interpersonal aspect. Like my privacy is not only my privacy, actually, like my data doesn't only concern myself, but also attached to the others. So in this respect, you can approach in two ways. One, like being less, like making the data subject less vulnerable, and second, antecedent autonomy, like glorifying someone's autonomy, antemortem, that will reflect on postmortem. So if we're on the same page on like why we should care, we should also, of course, care for IR's proprietary claims, like property, like etc. So the whole point was like, so there are two main approaches to solve this problem. Like how will we balance these interests? So first, it's personal right approach, and second is property. The problem with property is actually really straightforward. If we propertize all digital domains, first we have a problem that's been discussed for 2 decades approximately. Propertization also of personal data, which would be against all the contemporary developments in personal data literature, GDPR, etc. But more importantly, to the point we have here, propertization would mean there are no personal rights whatsoever post-mortem, because they will all pass to the IRS or whoever is in fact. Although, admittedly, yes, it will devise a right to control. In a minute, I will finish my introduction and tell it to you. And the personal right, the property problem was that, and personal right approach, personal rights, typically, like there are some exceptions, but they typically cease with upon death. Upon death, we can't really have any personal claims litigated. There are some exceptions, again, certain libel claims or ECHR precedent nowadays is prone to a bit of family privacy, but not in the form we want, like what we expect when we mention postmortem privacy. Given that, what can be the solution? Like what can be middle ground, like balancing? I defended, or I attempted to defend, perhaps we can go with a quasi-property as a middle ground, like balancing line. So what is quasi-property? Historically, quasi-property is derived from American common law, related to human remains, corporeal, like tangible human remains. And there were similar problems to the extent that certain academicians mentioned, like interpreted quasi-property on human remains is basically constitutional privacy, right? This is extreme. I'm not claiming this, but there is a limit. So what is this? For objects that resist to commodification, like it can be personal data, it can be human real. They, for certain reasons, it can be contemporary norms, or the object itself is not aligned with proper proprietary schemes. We see that quasi-property entitlement emerges, and the first one, as I said, right to sepulture, which means, so we do want actually survivors to have a custodial entitlement over the corporeal human remains, but obviously we do not want to commodify the corpse. Thus, we're refraining from property, like assigning the property right. Nonetheless, somehow we have to find a middle ground, which leads us to right to sepulture. So alienation and transferability are not there, but custodial entitlement and internment, like when we talk about the corpses, are there. But obviously, it's really straightforward. Like I'm not telling just because human remains, human corporeal remains were subject to quasi-property. I'm not claiming there's a direct link to digital remains. But nonetheless, it has been like, it started with corporeal remains, yet it had been transferred through American Supreme Court and Second Circuit and other state high courts. Quasi-property has been used in information, not for the same reasons, nonetheless, the same people entitlement. It has been used for hot news information misappropriation, trademark dilution, and trade secrets. I will not delve into deep, just to give an idea. Hot news misappropriation, for instance, the Supreme Court decided that direct competitors are bound by like they're under the duty to be refraining from the hot news for a certain amount of time, which resembles the general features of a quasi-property, which are firstly status of parties. In digital remains case, it will be, for instance, the platform, which is under information fiduciary conceptualization, under the duty of being loyal to the data subjects trust, which can also relate to, of course, conceptualization of privacy as trust by Professor Hadassah Waldman, etc. But most importantly, status of the parties, the context, in which context this data was shared, to which extent it was supposed to be used. And thirdly, the nature of the wrongdoing. Platforms is easy, I assume. In this quasi-property scheme, like platforms are by default the usual suspect. They're under many obligations during a data subject's life. Professor Birnhack mentioned that our recital 27 of GDPR to a certain extent limits GDPR's application. It depends on the member state, and many member states, especially, for instance, Germany, which prefers full corporatization, do not choose to facilitate postmortem privacy. Thus, what quasi-property offers in this regard is, so firstly, it by the status of the platforms, it provides a high threshold, like nearly strict liability, like in proprietary force manner, nearly a strict liability on platforms side, which will avoid, which will limit, or which will hopefully stop any postmortem exploitation, any postmortem misuse of data. But on the other hand, the quasi-property scheme through information fiduciary also ascribes certain duties again, like on the platform side, against the usual fiduciaries, the state executors, depending on the precedent autonomy of the data subject, the estate executor would be limited on access if necessary. Eventually, what I hope by the scheme is balancing the interests, firstly by prioritizing the data subject precedent autonomy, and secondly, following the precedent on corporeal human remains. I am inclined to ascribe the secondary right to the spouse or partner or life partner of the deceased data subject, again due to the prevalence of autonomy. Like I interpret it as at least the person has a choice to choose the life partner, and then thirdly, it's again spills over to the family members, which is second best option. Like I'm not really inclined to favor that unless someone has to deal with it. So hence this I guess concludes the scheme. I hope I didn't make it too unclear, but you're all welcome to ask further questions for clarification. Thank you very much.
Thank you.
Thank you very much for the invite, and I really enjoyed Mustafa's paper. I think he weaves kind of completely otherwise completely different discourses, privacy, property, courts, digital law in a very nice, illuminating ways. So I have some comments. Let's start with the kind of a macro comment and then several micro comments. So the macro comments is that I think there are three different parts to the paper. It's more about the kind of setup or the structure of the argument. And I'm not pretty sure how the three parts fit together. The first part is a very, I think, interesting kind of elaboration on the nature of quasi-property in American common law. The second one is about digital remains and whether we should entitle people with those kind of property rights. And the third one is about the management of digital remains by reference to, let's say, fiduciary concepts and so forth. So I'm not sure what would be the best way to kind of take all those three different parts together, especially in one paper, right? I think there's, you can focus on each one of them, I think, merits its own kind of study. And so I think you should kind of try to think, and we can discuss it later after the session, whether there may be different other ways to kind of take them together, but in a way that would benefit one aspect. I mean, you could write a whole different paper on quasi-property, right? What it is, what's the nature of it, whether it makes sense. There's another paper about how to think about digital remains, and there's a third one, which is what would be the best way to manage digital remains. And I think you can agree with one of them, but not with the others. And so I'm not sure how to wrap it up in one paper, especially, it's not a book, it's only an article. So that's the kind of macro. And so I was willing to think about what's your theory of kind of collecting the three parts together. in this paper and why we have to have it in this way. So let's move to the kind of more micro comments. The first is about the quasi-property concept, which I think you can understand my comment as a kind of semantic point, but I think it's substantive. It's not semantic, which is that I think the idea of quasi-property in a way reifies or reinforces false ideas about property. In a way, you say, well, there's property which is identified as full, absolute, maximalist idea of control and use rights, and there's the rest, which is because property is this kind of maximalist idea of use and control rights, then we have to open up a different category, which is quasi-property. But again, I think that's a false idea of property. Again, you could, and this is what part of the semantic part, but I'll get to the substantive one. You can start with kind of full ownership, which is the maximalist idea of use and control rights. But property consists of many other configurations of use and control. Right? Think about easement, think about riparian rights that you mentioned in the paper, and many other views of how to use the idea of property, which in my view, it's not about exclusion, it's about the power to, in a way, decide or to change the normative situation of another person with respect to a resource asset. And so I'm not sure that you have to make all those kind of concessions in order to kind of open the way for quasi-property. But just you could just say that there are different ways to think about use rights, control rights, and they are all could be understood as one variation on the big kind of property theme. And so I'm not sure that you have to reify or reinforce this kind of, I think, false idea of property in order to make open the door for your idea about how to think about digital remains as quasi-property. The substantive point here behind this semantic clarification is that the lesson, I think, the bigger lesson is that there is no kind of property in the air. Property rights, in a way, respond to some justification, to some reasons. We give property rights, we give entitlements and resources and things that we could all share because we have certain reasons for that. It applies to everything in property. And so does to digital remains. So once you have the justification, once you have the reason why we want to provide some use rights, proactive and control rights over digital remains, then property right is the legal language in which we kind of say, well, we think that this justification, this reason merits some protection, right? And so it applies also to full ownership to everything in property, right? And so I think that's the substantive point, which is that we shouldn't be afraid of using the category property or the title property, because if we understand exactly what it means, what the justification is, so what's the scope of the claim, then all those kind of views about, well, it is necessarily about commodification, right? The Julie Coyne kind of aspect. Well, that's not true. It doesn't have to be that way, as long as we understand exactly what's the limit of the claim, what is justification, and so on. And so that's the point about the quasi-property and how to think about it in terms of property. A third point is that when you touch upon courts and the US version of negligent infliction of emotional distress or intentional IAD and NIAD, I think one thing that I wanted you to push further is to make a kind of a distinction between emotional harm and dignity harm, right? Because some cases involving digital remains are not necessarily about emotional harm on the part of the deceased or relatives or others, right? Sometimes it's about dignity. And so those two things that we should tortify or make digital remains subject matter for tort cause of action may face this problem, that not all those cases in which we use digital remains inflict those kind of emotional harm, right? Sometimes we want to claim something about dignity rather than emotional harm. So I think you can push back against those who wants to kind of frame it in terms of torts by saying, well, it's not just about emotional harm. There are much more than emotional harm. in those issues. And by the way, this is just kind of footnote. There's a very interesting case, Lanier versus Harvard, which deals with kind of photographs of slaves and whether some relatives may have some property interest in those photos, or those are now owned by Harvard and they're presented in museums there. And so that's a very nice way to see how the Supreme Court of Massachusetts tried to, in a way, engage with some questions that may not be the same, but you could see how your Ford's property frameworks may fit or may not fit with how those justices try to figure out how to think about other remains, or not just digital remains, but a different kind of remains. And last point about the fiduciary regime. And so I do understand that you want to have this kind of bifurcated or kind of separate regime of managing digital remains. We have the platforms and we have the executors or the family. And I'm a bit skeptical about this idea of fiduciaries, the platform of fiduciaries. But let's just leave it aside. The worry here, I think, is that what's left outside is who should care for the public interest, in the sense that platforms may have an interest in digital remains only insofar as it serves their business model, however defined, and executive estates and relatives may care for their interests, including the deceased. However, there are some information there that has some public importance, right? Even if those people are not public figures, still there are some things that we may want to have access to. And so I'm worried in that stage of managing those digital remains. Is there a legal kind of way for the public interest to weigh in and to see whether there are some good reasons for exposing, giving access, to people in the university who want to do some study about, how people did something, or just for the public to know. And so I just had this question about whether there is a missing will in this management regime that would care for the public interest. Yeah. Thank you.
Right on time. Yeah, to respond. Shortly.
Thank you very much. So about the macro comment, yeah, I have my own doubts about the whether the articles on Medium can include this many layers. If it's okay for you, I would also like to discuss afterwards. On micro comments, so especially on this reinforcing false, I do agree actually, especially considering even pluralistic views of property. Once we have that approach, it's quite exactly taking us to a wrong image of property. Why I refrain from why I choose quasi-property over property. So especially in the 90s, there were these several articles beginning of 2000 and of 90s data markets, commodification of data discussions, which were really refuted for the right reasons. But again, that's true. Again, I agree a little bit with the false image of property. So it might be the conclusion might be that actually because of a semantic caution, I victimize the substance. That might be the conclusion. I will have to think about it, to be honest, but yeah, that's true. I was also uneasy quite a bit about throwing away property altogether. But then the problem is I have to really explain from the scratch that property is actually not what you think, and then I have to think about it. But yeah, I fully agree. On the emotional dignitary part, again, I fully agree. I actually had more parts on it. I reduced to fit in a readable length. And fiduciary regime, yes, again, maybe I should compare. Like I'm on this self-reflective phase of mine. So like it's not that like I just only agree. I really do agree with all the conflict. The fiduciary regime do have firstly this problem and also other several problems, contrasting loyalty, etc. Public interest. I'm trying to think like who exactly like I do agree, yes, like if we're devising a scheme, we have to also include the public interest advocate. But on the other hand, I'm not sure who is that right now, like with platforms, for instance, who's the agent that acts on behalf of the public interest. I think I have to have a research on it first and then make a conclusive decision. All in all, I basically agree with all of your critics. And I would like to afterwards also in that. But thank you very much.
Thank you.
Thank you. So first, Mustafa, thank you very much. It was really, I really enjoyed reading paper and I found it very inspiring. I think maybe, in my opinion, we just give up the idea of privacy as quasi-property too soon, and I think you might consider to elaborate more on that. But my question is actually about if I understand you correctly, the pre-assumption or the presupposition behind the idea is that we do not want or we think probably like it's immoral or unethical to consider personal information as a commodity. So my question is from what point of view? Because maybe I do not want my personal. I mean, in the political conversation around the propertization of personal information, usually we know that it is also already commodified. But by whom? And who is who gets the benefits from that? So we are as data subjects are not allowed because it's immoral to think about it as a commodity, but it is bought and sold, and and not only by platforms. So first of all, I think there are in fact property rights in personal information, and I don't know, you have the data collectors, owners, sellers, brokers, they all sell personal information. So what is the use of having this quasi-property regime if it's not like before we commodified the information? And also you can see that this information, the remains, are commodified after that. I mean, it's also by family, and I think that probably Mauricio knows about that more than I do. But so maybe you would say something. But I think that
Surely, no, perfect. Like it seems like I agree with all the critics, but that's true. I also think like these things at the same time. You're right. There's the Kurtola rights on this. Exactly, basically saying what you say. Like it's already commodified, so why should we not take into account? But the thing is, there's if you'd ask me, like there's a right to control. Yes, especially Professor Julie Cohen and professors like her, like one of the main concerns is that like when you commodify, like fully commodify a resource, the ones in the bottom of the stratification suffer the most, while like etc. So also following the GDPR semantics and to a certain extent merits, but more semantics, GDPR follows like yes, it dresses rights in a market, basically. Like So that's actually what I tried, like what I had in mind, like dressing, like I'm not actually trying to like altogether overlook commodification. I am fully aware. So that's why I was trying to find the way that will be in line after that with GDPR before that. Because GDPR also does that, like they're also aware of the commodification, so they dress rights in a, like they are all for reification, but not commodification, if it makes sense. Like, so that's what I was trying to reflect by this quasi-property. I hope it answers. Did you have privacy as a quasi-property? I left it too soon. Perhaps. That's, I'll think about it.
Now it's you.
Thank you, Mustafa. Thank you so much for the paper. First things first, I really appreciate the fact that you explained the quasi-property idea in depth, as opposed to some critiques. Because in my case, as a continental lawyer, this is something very new to me, rare, strange, like
for me too, actually.
like a very interesting idea, which has like different shapes and meanings. But I would like to make two questions on your paper. So let's take a look at what you said in page 31. If you allow me, we'll read it. You said, under the theoretical scheme I defend,
Jesus.
a brief relative can exclude digital platforms from postmortem data collection, processing, and exploitation. The exclusionary framework is not triggered by ownership of data, but by the claimant's status in relation to the deceased and the nature of the defendant's action. So I think that this is your claim very well explained, that you are not granting property status to these remains, but this is because of this relationship, right? That something is out there that prevents exploitation, collection, and so forth. And on the other hand, the executor, which is a family member as well, cannot access certain contents. But I don't understand how this scheme is going to take shape in legal terms. Is it going to be in your idea? And I'm sure that this is something that you develop in your thesis, not in the article, but possibly in your thesis. And then, is it going to be shaped by terms of service, by a contract, separate contract, a standalone contract itself, by statutory law, like by law reform? How? And then the second question, and I'm sorry if I'm taking this to a different direction, but as a former practicing lawyer in public law, I am very concerned with who enforces this quasi-property scheme, because I mean, are you leaving this to the court, to the judicial system? Are you leaving this to the executive branch, to offices, Ofcom, data watchdogs, and so forth? Or are you leaving this possibly to other certain stakeholders, such as notary publics, public notaries, which in certain cases they enforce a lot certain types of wills? I assume that in a certain in a way that you lean towards the courts, since you mentioned that it can complement itself. This is scheme that you propose, it can be complemented with torts. But I don't know, like I would like you to question to answer by yourself. Thank you.
Thank you very much. Firstly, so what like this the structure, I have actually data trusts in mind, like a newly burgeoning data trust. They're complex, like a complex of contracts, basically, like a couple of binding, like creating a trust, which so for newly developing data trust, for designated for this function, there is no problem, obviously. But what will we do with the platforms, incumbent platforms, which are the real deal right now, actually? So what I had in mind again was information fiduciary, which again has its own openings and problems. I have to like solve these problems. But Balkin, for instance, like Jack Balkin is championing this view, using the incumbent fiduciary normative grounds to somehow burden the platforms after that. That's what I had in mind. I actually, maybe I should also explain, Professor Edwards actually, like, I assume, I don't want to obviously like presume further, but I guess when you had this, the scheme, like, I mean, not for postmortem, but it was in the early days, right? Like long before GDPR, so privacy literature was like all around the place. So I kind of feel the same with postmortem privacy. Like now with GDPR and neighboring tools, it's a little bit more settled, like antemortem, but postmortem privacy. That's why I used also Professor Edwards and applied it on this kind of like coupling with information fiduciary and quasi-property. So what I have in mind is basically data trust and whether information fiduciary scheme can go a lot with already incumbent platforms. I can't find a perfect counterexample that it won't, so I have to develop further. And what I had in mind was on the enforcement was private ordering, because I always thought it was a complementary, not substituting altogether, but a complementary to an already incumbent system. I don't think we have. Is it, one last remark. I don't think we would have a real problem with private ordering, like as opposed to regulation. But yeah, like again, going back to Professor Dorfman's comment, private ordering is not normally not for public interest, for instance. So like there is also a hole there, like I am aware of. Thank you. Thank you.
I wonder if I can comment a little bit to that.
Just, we have another question before, and then we'll have.
It's just that this ties to
Oh,
what was
okay.
just being discussed.
All right.
It's not really a question as such, because I think you're beyond me in terms of property law, but as a sort of historical comment, when I invented data trust, I think this ties into what the commentator said as well. I was drawing on my experience of teaching the Scots law of trust, which is quite esoteric because we are a mixed jurisdiction in the same way as Israeli law is, in fact. And it draws on continental ideas of fideum commissum, as well as having been polluted to some extent. It's how it's viewed by Anglo-American views, common law views of trust. So in my view, in my head, when I was writing that, I was actually thinking of the contents of the trust, which did not just include personal data in the GDPR sense. I was actually talking about things like cookies and likes as well, because the fundamental idea was to bring revenue to the data subjects in GDPR parlance, right? So there was stuff in there that wasn't necessarily at the time thought of as personal data that we do now. My view was, I think, that it was property, right? And it's only since then that that's become disputed very much by more purist ideas from the common law, as expressed particularly, I think, in Chris Reed's memorandum, which I now see he's got published, for which thank you. But I suppose what I would want to say is a bit like the commentator, is that I don't think it does much. I don't think it butters many parsnips, a phrase we have in my system, to be too purist about this, you know, because if you go to certain, I mean, Adina has done a lot about this in her thesis, and since if you go to certain conceptions of the common law in England, at least, maybe as opposed to some US states, you will find that intangible items of liability, such as choses in action, can be regarded as items of property, right? Which we would again find slightly odd in Scotland, right? So I kind of agree that rather than settling down on some conceptualization of quasi-property, it's probably best to think of this in terms of what you're trying to achieve, you know, and sometimes what you're trying to achieve can be best met by, as Chris Reed suggests, incorporating a data trust, rather than trying to depend, as Sophie Delacroix does, on some very purist, very continental conception of, you know, what can go into a data trust, which I'm substantially in disagreement with. So I suppose, yeah, it's very interesting to see it laid out this way, because I hadn't thought about it in the post-mortem context. But I suppose I'm saying, yeah, that if debts can be property, then why can't data in this context, but not always? And of course, the contrary reason to address the question that was asked over here for saying that data, personal data, shouldn't be propertized is not, in my view, moral or ethical, because I don't think that's the view of the place of the law. It's because it restricts freedom of information, right? Because you can monopolize it, you know, in the same way as intellectual property does, right? And, you know, Neva would be much more expert here. And that's the reason to push back on that kind of commodification. So if that isn't a danger here, then maybe we don't need to push back on commodification. So that's my very pragmatic view.
David, last question.
Two, I think, relatively quick comments. One is, Question is whether, and this is a theoretical one, of whether to go with quasi-property or whether to stick with, let's say, more well understood regular property. Because remember, regular property is not on or off, that they're all different angles. If we take like copyright, we have, let's say, full copyright, we have the moral rights and certain limitations, we have copyright just in selection and arrangement. So, and trademark law, I don't have a complete, control over the name, just if it's confusingly similar, just for certain goods or services. So maybe just to think about property not being on or off, but different levels, and maybe if that's a possibility. The other thing, and this is the practical lawyer, not public lawyer, but a private lawyer, which is we're always thinking about how do we implement these things in policies. And I want to go to the when Avichai talked about like the third part that sort of ties in with Tal and Michael, which is we generally feel like the continuity of the same state, the principles that we chose ante-mortem, we also want to have after death. And I was thinking with platforms, it's easier to continue probably the same policy, but I was thinking this, which is, really most of our privacy, is here. And of course, like as the father of three, self-respecting millennials, who of course not only know all my credit cards and the last 3 digits on the credit card, but of course also know my password to get in here. That this has all the different conversations, including of course my different conversations with my different kids that are not always on the whole family WhatsApp group, but different things of talking about each other too, if they give a shit afterwards. But like that is in terms of implementing, how do you actually have a policy that really protects this, which is probably the stuff that you did not want everyone to know, especially the executors, administrators, and those who are really going to be looking at this thing.
And it's not here,
I understand.
And encryption, what do you mean?
Yes, sadly, for at least American criminal procedure, it would actually be protected. But for instance, so I also worked on German law, like the other continental countries, succession laws. Sadly, for instance, in continental, like mainstream understanding, no, there is like actually they are any tangibles actually with digital data in it does pass on to the next in line. But yes, exactly, like I was thinking it from the beginning, actually from my PhD's beginning. Is there a way to like encompass also life, for instance? I'm not so sure, because even with this level of protection we want in digital postmortem era, actually there is a huge backlash, especially in Germany, for instance. So even this caused a lot of resistance. I'm not sure extending it to offline would be that feasible. But I perfectly agree, and I actually do share your concern. The real deal actually most of the time are these kind of devices. But yeah, thank you very much.
Thank you. Thank you. Thank you all the speakers and commentators. We will reconvene at 2.
We convene at 2 o'clock, so you can grab lunch at the cafeteria downstairs. Speakers and commentators follow me.